Section 9. Overview of Title 45. ARS. Water in Arizona. Connecting water. Due diligence to Arizona law. In the last section, we discussed additional water considerations such as grandfathered water rights, water priority, assured water supply changes, ADAWS, and commingling water certificates. Now we are going to connect those practical issues to the legal foundation behind Arizona water regulation, Title 45 of the Arizona Revised Statutes, commonly referred to as Title 45 ARS. If the previous sections helped us understand the what and why of Arizona water, this section introduces the legal framework that helps explain how Arizona regulates, protects, allocates, and manages water. For real estate professionals, Title 45 matters because water can affect property value, development potential, buyer due diligence, agricultural use, well rights, water delivery, long-term ownership costs. Disclosure and risk management agents are not expected to memorize every statute in Title 45. However, agents should understand that Arizona water rights are not casual assumptions. They are governed by law, public policy, regulation, and recorded rights. What is Title 45 ARS? Title 45 of the Arizona Revised Statutes governs water law in Arizona. It addresses the regulation, use, appropriation, storage, and management of water resources throughout the state. In simple terms, Title 45 is one of the major legal sources that explains how Arizona treats water. This includes issues involving surface water, groundwater, beneficial use, water rights, water storage, water exchanges, conservation forfeiture of unused rights, public ownership concepts. For real estate professionals, this is important because water is not just a physical resource. It is also a legal right that may or may not be connected to a property. A buyer may purchase land and assume, if water is nearby, I can use it. Title 45 helps explain why that assumption may be wrong. Surface water under ARS, Paragraph 45-141. One of the key statutes in Title 45 is ARS, Paragraph 45-141, which addresses the public nature of Arizona waters and the concept of beneficial use. Under this statute, many waters of Arizona are considered public waters. This includes water flowing in natural channels such as streams, canyons, lakes, ponds, and springs. It can also include flood, waste, or surplus water. These waters may be subject to legal appropriation and beneficial use under Arizona law. This is a major concept. Just because water touches or crosses land does not automatically mean the landowner owns unlimited rights to use it. For example, a rural buyer may see a seasonal wash, stream, or pond on a property and assume they can divert that water for irrigation. In reality, that use may require legal rights, permits, or further investigation. That is why agents should encourage buyers to review water rights carefully before relying on any water source. Beneficial use. Use it productively. Title 45 places strong emphasis on the concept of beneficial use. Beneficial use means water must be used for a productive, recognized purpose. Examples may include agriculture, municipal supply, industrial use, or other legally recognized uses. The key idea is that water rights are tied to actual use. In Arizona, water rights are not meant to be held forever without being used. The law generally favors active, beneficial use of water rather than allowing someone to claim water and never put it to productive use. For real estate professionals, this matters because a seller may say, this property has water rights, but the buyer still needs to know what type of water right exists. How much water is allowed? What use is permitted? Has the right been maintained? Has the water been used consistently? Is the right transferable? These are not questions agents should answer casually. They require review of legal records and professional guidance. The 5-year non-use rule. Another important concept under ARS Paragraph 45-141 is forfeiture for non-use. If the owner of a water right does not use appropriated water for 5 consecutive years, the right may be forfeited, and the water may revert back to the public for appropriation again. This can be a major issue in real estate transactions. Imagine a buyer purchasing agricultural land. The seller claims the property has valuable historic water rights. However, during due diligence, the buyer discovers the water has not been used for many years. That raises an important question. Are those rights still valid? The answer may require legal review, ADWR records, and possibly water rights professionals. This is why agents should avoid making guarantees about water rights, simply because a seller says they exist. Underground water storage. Title 45 also recognizes the importance of underground water storage. Storing water underground for future use does not automatically count as abandonment or forfeiture of the water right. This supports modern water management practices such as groundwater recharge and water banking. This connects directly back to our earlier discussion about the Arizona Water Banking Authority and recharge programs. Arizona does not only use water as it arrives. The state also stores water for future use, especially during times of shortage, drought, or high demand. For real estate professionals, this helps explain why Arizona's water system is more advanced than many buyers realize. Water exchanges and substitutions. Title 45 also allows certain water exchanges and substitutions without automatically causing abandonment or forfeiture of rights. For example, certain arrangements may involve exchanging surface water for groundwater, effluent, Colorado River water, or other sources. This connects back to our discussion of commingling and alternative water supply planning. Arizona's water system is flexible because different areas rely on different water portfolios. A community may use a combination of cap water, groundwater, reclaimed water, and stored water credits. That flexibility is important for long-term planning, but it also means water rights and water sources can become complex very quickly. Water conservation does not mean losing rights. One concern some water users may have is, if I conserve water, will I lose my water rights? Title 45 addresses this concern by recognizing that certain water conservation efforts do not automatically result in abandonment of water rights. This is important because Arizona wants to encourage conservation, not punish it. For example, a farmer who improves irrigation efficiency should not automatically fear losing water rights simply because less water is wasted. This supports the broader theme we have discussed throughout the course. Arizona's water future depends on smarter use, better planning, and responsible management. Creating a water portfolio for a property. One practical takeaway from Title 45 is that buyers and property owners should understand their water portfolio. A water portfolio means identifying all water-related sources, rights, obligations, and limitations connected to a property. A property's water portfolio may include municipal water service, private water company service, well water, hauled water, surface water rights, groundwater rights, irrigation district service, HOA water obligations, CFD or improvement district fees, water storage or recharge rights. For real estate professionals, this is a powerful way to explain water due diligence to clients. Instead of asking only, does the property have water? The better question is, what is the complete water picture for this property? Special districts and water costs. Title 45 concepts also connect to water-related costs. Some properties may be located in special taxing districts or improvement districts that affect water infrastructure, billing, or long-term assessments. These may include community facilities districts, water improvement districts, HOA managed systems. Private water providers. A buyer may focus only on the monthly mortgage payment and forget to review water-related fees. That can create surprises after closing. Agents should encourage buyers to review title documents, HOA disclosures, tax records, water provider information, and utility billing structures. The agent's role. Under today's standard Arizona water law can be technical, but the agent's role is practical. A real estate professional should recognize when water may affect the transaction, encourage proper investigation, avoid making legal conclusions, recommend reliable resources, direct clients to ADWR, a DQ, title professionals, water attorneys, engineers, or well inspectors when needed. The agent should not say, "Don't worry, the water rights are fine." A better approach is, "Water rights can be complex in Arizona. Let's make sure you review the appropriate records and consult the right professionals during due diligence." That is the modern standard. The practical takeaway. Title 45 ARS gives Arizona its legal structure for managing water. It helps explain why water is public in nature, why beneficial use matters, why unused rights may be forfeited, and why conservation and storage are protected. For real estate professionals, the goal is not to become a water law expert. The goal is to understand enough to recognize risk, ask better questions, and guide clients toward reliable information. In Arizona real estate, water is never just water. It is law, value, infrastructure, development, and long-term planning all connected together. Online discussion. Question 1. Why is Title 45 ARS important for Arizona real estate professionals? Answer. Title 45 provides the legal framework for Arizona water rights, water use, storage, conservation, and regulation, all of which can affect property value and due diligence. Question 2. What does beneficial use mean in Arizona water law? Answer. Beneficial use means water must be used for a productive and legally recognized purpose, such as agriculture, municipal supply, or industry. Question 3. Why should agents be cautious when a seller claims a property has water rights? Answer. Water rights may depend on legal records, historic use, continued use, registration, and compliance. Agents should recommend professional review instead of making guarantees.